First of all, I'd like to wish everybody a good afternoon and thank you for joining us on this webinar on how to prepare your business for sale. Just a few points before we start. If you could all keep yourself on mute whilst we're going through the presentation, that would be really good. And also, as we go along, please feel free to ask any questions in the chat box and we'll filter them through as we're delivering the webinar. And finally, at the end, there will be an opportunity for Q&A as well. So if we begin, that would be great. So Rachel, will you move to the next slide? Brilliant. So just a quick introduction on FDS. We're an award-winning corporate finance firm established for over 30 years. We've helped over 400 plus transactions on supporting owner-managed businesses on their business journey. So working towards that successful succession planning and looking at all those strategic options that may be suitable. And it depends where you are on your journey, whether you are in the growth stage and you may want to look at acquiring businesses, or at the end of the journey in terms of handing the business over. And Alice will just do a quick introduction on Pepperells.
Hi everyone, so just a little bit of a brief about Pepperells. We're a modern, dynamic, growing law firm. The team's made up of around 160 legal experts, and we've got offices in Lincolnshire, East Yorkshire and the North East. We've got a growing team of corporate lawyers that have huge knowledge and expertise in the business sector, and we advise companies on a range of different corporate matters, offering pragmatic, clear and proactive advice, whilst focusing on the business's commercial needs. And then I'll hand it back over to you, Fiona.
Thank you so much, Alice. So I'm going to kick this off. Just a quick introduction on me. I'm Pepperells. I'm the Managing Director at FDS, qualified accountant, mum of 4. Can I just ask Cheyenne to put themselves on mute? Thank you. Mum of 4, been with the firm for over a decade now, and it's myself and Joe Haig that lead on all the transactions, manage them right from the beginning to the end. So just on preparing your business for sale, why is there need to plan ahead? Without a plan, you don't know where you're going, what you need to achieve, and there's various reasons that you may be looking at what the succession planning may be, and that is, you may have just lost interest, or you've got bored and actually you don't have that drive anymore, or you've taken the business to a certain level and now you're looking at, right, okay, I need a big brother now to take it to the next stage, and how do I do that? You may be falling out with your fellow shareholders and directors, and you think, actually, we need to just look at where we're going with this and how we're going to solve the issues that we currently have. And it's all of those. And for us at FDS, it's all about plan early. Think about your vision and your strategy. Where is it you want to be, as well as the company's objectives? What are your personal objectives? And we can help navigate you through that journey to help and achieve those objectives. So at the moment, in terms of transactions, there's a few things that we have to take into consideration. First of all, the Entrepreneurs Relief Clock. This was changed last year from a £10 million allowance to £1 million. And the thing here is that, and if anybody doesn't know about Entrepreneurs Relief, this is where you can sell your business and only pay 10% capital gains tax on it. And it gives you that relief to pay at that lower level. So there's that, and it's been mooted many, many times by the government that this is an area where they will be changing the tax rate. So first of all, to bear that in mind, that, at the end of the day, it doesn't matter what value you get in terms of gross consideration. It is all about what are you left with after you've paid all your taxes. So something for you to think about in that regards. The next thing is that, trade deals are taking longer than they used to. They are on average taking 12 months to complete from start to finish. And that's because due to all these uncertainties at the moment and things like that, there's a lot more focus on due diligence. So preparing your business for sale needs to happen much, much sooner, and you need to be looking at that detail well in advance to make sure that you've got all your ducks in a row. With Brexit and then COVID and everything else that's happening, you know, it's very difficult to predict the future, and all the crystal balls have broken. So again, you know, the more we can look at that strategic focus, the more that we can plan, and the more focus that we can take on board of what our objectives are, and the more time we can spend working on the business rather than in the business, that is all really going to help in terms of meeting the objectives that the company will set itself and your personal objectives. And with transactions, resilience is a must. You've got to, you know, there's a lot of brinkmanship in transactions, and it's all about having the right advisors surrounding you to navigate you smoothly throughout that process. And everything takes longer than you ever think, and everything goes as smoothly as you hope. But this is why, you know, having FDS and Pepperells around you as those advisors will help that process immensely. Moving on, Rach. Again, please, everyone, if you've got any questions whilst we're running through this, these slides, please feed them in, and we will come to you as quickly as possible. So when we're looking at a trade sale or a private equity sale, and the difference between those two types is just a trade sale is selling to somebody already in the trade, where they may have lots of synergistic opportunities and complementary services, and a private equity is a large corporate player who buys a number of companies and really let the management team run the business and really oversee that process. And you know, their objective always is to sell in 3 to 5 years to get their return for their investors. So the process in both trade and private equity sale is the same, and at FDS we would explore both routes to ensure that we've got the widest net possible. But part of that process, the first thing we need to do is make sure we do evaluation of the business, because what we want to do is make sure that we're aligned to your targets, what you believe the value to be. And because the way FDS works, we always want to make sure that, you know, the alignment is there, and that we believe that we can achieve what you want to achieve. And sometimes that's not all about value, it's finding the right ideal home for a business as well. But we've got to be on the same page, because otherwise we won't do our service justice. The next step is to get the relevant tax advice. Again, planning is key. The sooner you bring on board advisors to look at a plan where you want to achieve it, clever tax advisors can ensure that, you know, sometimes if it's 5 million that you want to achieve, well, you may be able to achieve 5 million through different tax mechanisms, and getting that gross consideration as low as possible is always going to help. So just to bear that in mind. We also are very proactive in what we do, and we are different to others in the market in the sense that we are proactive, and we will do a full researched target list. So we've got a database of over 600 referrer contracts. But the other thing is that, you know, when we engage with a client, we will do a specific target list of who we think are the likely buyers. Now, they may not obviously be out there saying that they are looking for acquisitions, but because of the way that we work and the way that we investigate each target, it could be a good fit, and it's exploring all those options. So our target lists are at least 50 targets. It's not just a handful, and we would go to that wider market as much as possible. additionally, once we engage and we're looking at preparing the documents to go to sale, another document that we have to prepare is a teaser document. This is a one-pager, really, and the teaser document is on a no names basis, so we protect the confidentiality of the business until we need to share that, and we only share the name of that business once we've got a non-disclosure agreement in place. So the teaser document is a one-pager that tells any interested party a little bit about the business in terms of what sector it's in, where the geographical location is, what are the opportunities, a summary of the financials, and the reason for sale as well, because depending on that, you know, you'll get different interested parties interested. But it's just really giving that little bit of a overview of that business to see if that interested party is interested and wanting more information. Once they've looked at the teaser document and they say, yes, this is something that we'd like to look into further, we would send a non-disclosure agreement, get that in place, come back to you, and then we'd issue an information memorandum. Now, the information memorandum document is your Bible as such. And within that information memorandum document, we will talk about the past, the present, the future, the management team, the opportunities, the financials in a lot more detail. It's to provide that interest party with sufficient information for them to get a really good understanding about your business, for them to assess if that is firstly of interest, and then secondly, you know, are they prepared to pull an offer together on that business? So again, just to summarize, we never put a price on your business to interested parties. Though we've done evaluation and we've got an idea, we want to be able to maximize your position as much as possible. And as part of that, it's all about the presentation. So we have in-house designers preparing all our documents from start to finish, and it's because we've done this so many times, we know what buyers want to see, so we're really good at picking out the important factors. And whilst background and history is important, they're more interested about the future. How is that going to work for them? How is this going to help their business and their overall objectives? So it's really key that those documents are of that high quality, high standard, and the content in them is relevant and enough for them to make those judgments. Moving on, we will do a management presentation as well. So once we've sent an information memorandum, the next point is to get them in a room in front of our management team. If we want to share it with our management team, I know that it can be confidential, but in front of the owner especially, to share our vision and where we're at. They want to hear it from the horse's mouth, where the business has been, where is it going, and to get that comfort. And then it's all a timeline process. So once we are ready to go to market, we usually give about 13 to 14 weeks for all those steps to be undertaken. And we'd ask on the information memorandum, we would set a date for indicative offers to be placed. We'd get all those offers in. Once we'd look at those offers, first offers are never final offers. We would work and negotiate those offers as much as possible. And then we'd work to a position with one buyer, keeping all the other buyers really warm, because you'd never know when a deal may fall over. So we have to keep them really warm. And then we'd go into an exclusive arrangement at heads of terms with one buyer, and we'd give them a time frame of about 8 to 12 weeks to complete the transaction. And it's all about, you know, keeping that momentum going and working through all the steps that are necessary to get to that successful completion. And, you know, as part of that successful completion, there will be full due diligence, legals, and tax advice throughout, and we do all the heavy lifting from that transaction. Moving on. So as I've mentioned just briefly before, you know, company valuation is key. It's like beauty, it's in the eye of the beholder. So just as an example, we sold a business a few years ago. We had a dozen bids. They all range from 800,000 to 5 million. There's a big jump there. And when we did the valuation, it came out to be about 3.5, 3.7 million. And the reason why we had this 5 million bid is that they really, really wanted it. That them buying that business would make a huge difference to their business. And the £800,000, they all had the same information, but they were just taking a punt, and that's the situation. So it does come down to who's looking at the business and what it means for them too. So again, part of our process is always looking at, well, what benefits would that have on them? And we work that as part of our negotiations. The method that used for most SME businesses is the weighted average of normalized EBITDA, EBITDA being earnings before interest, tax, depreciation and amortization. And again, we've got a real-time database that tells us what businesses are sold for, what multiples are being achieved. So they're very robust in terms of giving us a good idea of what we think is achievable. And plus we've got our own 400 plus transactions that we can draw down data from. The good news is, the PCPI multiple, even during this COVID period, has still remained at 10.2 times. That's an average deal size of 14 million. So the multiple and the data that we've seen, actually multiples haven't dropped, and there is still a big appetite for deals to happen, even more so now we've got our route to exit out of this COVID. So the market is very strong, very busy and very vibrant. And there's a couple of other methods of valuing a business. One is the net asset plus goodwill method, and the other one is industry specifics, depending on what kind of business you have. So insurance brokers and accountancy practices alike, they're very much based on an industry specific, which are based on recurring revenue. So just moving on, Rachel. So how to maximize value. These are some of the things that you should consider in terms of maximizing value. Now, a lot of these things we call are the hidden assets of a business. So these are not necessarily visible on a profit and loss or a balance sheet, but they do have lots of value attached to them. Again, we're really good at bringing these hidden assets to the forefront of all interested parties. So having an engaged management team that doesn't include you it will always increase value. If somebody's buying the business and it's not heavily reliant on the owner, that will really help, and it will excel valuation. Contracts for recurring income, like I've just mentioned previously. If you've got contracts and you've got recurring income, that does help in terms of maximizing value. You will get a higher value if you've got secured contracts in place. Having no customer concentration, so not being reliant on any one customer, trying to have less than 10% base with one customer is always a good place to be in. Anything more, really, any trade buyer would look and assess that risk of, well, if we lost that customer, what would happen? Being cash generative, of course, that's a bonus. And as part of valuations, any excess cash goes on top. So if there's cash that's not needed for working capital purposes, it would be an addition to the enterprise value of your business. Investment in R&D, pre-sale DD. So the pre-sale DD, again, the more you can prepare your business for sale, making sure you've got all your ducks in a row is all going to help, because any of those things that you haven't later in the process will only hinder the transaction, and it will, it causes opportunities for chipping, and that's what we don't want to do. So getting all that ready beforehand, before we go to market, it is always a good idea, because it just mitigates any problems further down the line. A couple of other things there is shareholders agreement, profit and add back. So add backs is really important, in the sense that you may have a reported profit, but if you've carried out transactions that are wholly one-off or discretionary, we would normalise those numbers, because what a buyer would be buying is what are they going to be taking on going forward. So I don't know, if you've had a major roof repair one year, you don't expect that to happen time and time again. You may have done a big marketing exercise one year and you don't do it again. They're all one-offs. And in this case, when you're looking at valuations, every pound may be worth £5, £6, £7. So it's really important that we do strip out any normalizations. And on the other hand, there's a lot of owner managed businesses that will take low salaries and high dividends. And if you are operational in the business, we've got to put that market salary back into the numbers to normalize that too. Moving on, Rich. So I think this is my final slide, but just to summarize, you know, from corporate finance point of view, it's all about keeping everyone in control, keeping everyone happy as much as possible. And, you know, sometimes we have to play bad cop, good cop. And, you know, we always say a deal's not done until it's done. So continue running the business as you would until that deal is done. So no plans of buying the yachts and setting off to the sunset straight away. And it's all about planning for the worst and hoping for the best. But, you know, having us as part of that team will really, really help that process. Thank you so much. So just before we hand over to Alice, there's been a couple of questions in the question box. Do you just deal with large businesses, or do you also work with very small businesses, and what are your fees? So thank you, Cheyenne, for that question. The point that we work with businesses that are looking at a deal size of $1 million to and above, really. And the reason for that is because of the process that we undertake. It is very in-depth, and whilst we have worked on smaller transactions, you know, it's all looking at that net position. Where is it that you want to achieve? But I'd be welcome to have a one-to-one with you, and we can pick that up in further detail. So the next one that I've received is, what's the average multiple at the moment for a small 10-person accountancy practice? Again, just on that question, you know, accountancy practices are valued not just on a multiple of EBITDA, they do look at the revenue. So again, I would welcome us to have a one-to-one and just go into that a bit more detail. You know, evaluation for us is very important. So I don't like to say things off the cuff, because to me, it's really about understanding that business and also looking at those hidden assets that we've mentioned, because they can make a huge difference. Thank you so much. Over to you, Alice.
Thanks, Poonam. So on the webinar today, we've got a couple of members of our commercial team. We've got Peter and Ella, who are both our corporate lawyers, and we've got Mark, who is our commercial property lawyer, and they'll be taking you through the important legal elements to consider when preparing your business for sale.
Good afternoon, everyone. Thank you for joining us on this sunny day. Thanks, Poonam. That was really, really excellent, actually. I've been doing corporate M&A work for almost 30 years now, and I'm hoping to share with you in this slide what I view as the real importance of preparing your business for sale early in the process. I can probably give you hundreds of examples of things that have gone wrong where business owners haven't prepared, haven't invested time upfront before they actually get into the live transaction, and almost inevitably it can go spectacularly wrong. That is either losing the sale completely, or at best giving the buy side the opportunity to chip the price, so you don't achieve what you either set out to achieve, or more importantly, what you ought to achieve, what the business value is truly worth. So I've given some examples here in the bullet point. First of all, what I want to say to business owners who will ultimately, we will all exit the business at some point. A business owner will exit. It just depends where. It can be something that is planned. that's the luxury. You can plan your retirement, you can plan your exit, which is great, but very often it could be an unexpected offer that comes in, or it could be a trigger outside of your control, which I'm about to come on to. But whichever it is, what I say to business owners, particularly if you haven't been through this process before, is do not underestimate the time, management time, emotional time, upheaval that is involved in going through a sale transaction, and with your lawyers and with your corporate finance advisors. It is really, really time consuming, but also really important. And Ella and I came off the back of a business sale. We're advising on the sell side, completed last week. It was a very, very difficult deal. It was an 8.5 million sale. And the difficulty we had was the seller, our client, didn't take the process seriously. And it almost derailed completely, actually. So this is just, please try and get in your head. You're going to have to go through the due diligence process anyway. You're going to have to get your business ready for sale anyway. So do it early in an orderly fashion, less stressful, and you will achieve a better outcome for yourself. So other reasons why you should prepare early. It's good business practice anyway. You know, as directors and shareholders, you've got fiduciary duties to the company under the Companies Act. You've got duties to act in the best interests of the business. So you're ticking all of those boxes. The second bullet point there, you will inevitably be mitigating the risk of exposure to litigation or things going wrong if you have robust documentation in place at all points. So make sure you have contracts in place with your key customers or key clients. Really, really important anyway during the life cycle of your business, but it increasingly becomes important in the sale process. Again, back to this deal we completed last week as an example. This company were turning over a lot of money, but they had one key contract which accounted for about 60% of their revenue, which they couldn't find. They didn't know where it was. So that is an issue for the buyer, obviously. If they're buying a business which is relying on one contract providing repeat revenue of 60%, that could be an issue. So make sure you've got contracts in place with your key suppliers as well, your customers and your clients. Very important. Excuse me. Employment contracts are important. Director service agreements are important. Shareholders agreements are very important. So when you come to the sale, everyone knows that they're on the same page. So you all have to sell at the same time. You all know what your shareholding is and your rights are. So write it down. Make sure this is. And back to the point I started with here. Unexpected offers do come in. I mean, we had a new start we acted for a couple of years ago, and they developed some quite innovative software solutions. And although they hadn't yet made any money, someone in America really liked this idea and could see how it could be rolled out over there. So they got a £15 million offer when they were only 6 months into the business, and they were massively not expecting it. So be always sell ready, because you just don't know what's going to happen or what's going to come at you. Apart from the ordered exit from the business, which would be a phased withdrawal, whether you deliberately determine to retire and sell your business, that's fine. But there could be trigger events outside your control, such as shareholder or directors' disputes, death, long-term illness, divorce is a common one actually, or breakdown in a family relationship, can all trigger the sale of your business, which is something you have no control over. So don't always think you can orderly leave your business in an orderly fashion. That is usual, but not always the case, and there are triggers outside your control. Do you have the next slide, please? So a big part of preparing for this sale is due diligence. We've bandied around a lot. Poonam's already mentioned this. What is due diligence? Well, there is legal due diligence, which we would also obviously deal with if we're instructed on the sell side or the buy side. And there's financial due diligence covering financials, obviously, tax, etc. The due diligence process is long and arduous. And again, I can give you no better advice than saying do not start due diligence in a live transaction arena. The reason for this is it can massively affect the price that you ultimately achieve for your business. And more so, it can actually kill a deal. So if you start, you're going to have to do due diligence anyway. So you either choose to do it in advance, so you get to the buy live arena and you've already got your ducks in a row. You've flushed out all your skeletons and they've all been dealt with. And you have this lovely shiny data room which will pull together with all of your documents in there, all the questions, all answers to questions that are likely to be asked by the buyers are already there. And that presents a massive front foot opportunity for the seller of a business to say to the buyer, look how good we are, we've already done this. So you get the due diligence questions from the buy side, and within a week, we'll open that data room and they've got clean data, and that presents your business in a fantastic light. It means it will ultimately get to completion much more swiftly. It will also mean that there is less or no opportunity for them to chip the price from that which you wish to achieve. And also, as part of the process, if you're giving this fantastic information and documentation at the beginning of the process, it sheds your business in such a good light that they're unlikely to delve more deeply. And on the converse side, I've seen transactions where due diligence has taken forever because we're not getting the client's buy-in, we're not getting replies when we should have them. And therefore, the buy side worries about that. What are they hiding? Why is this not in good order? And you know what? Human nature, they then start to delve more deeply in it with a view to chipping the price. And the biggest chip that I've known in recent history, 6-7 years, was a 10 million sale, and they ultimately achieved 1 million. And it does happen. It happens all too frequently. So as I said, you're going to have to do due diligence anyway. So please start to do it early. The other benefit is when we do pre-due diligence before the live transaction, we can find and hopefully deal with any issues of significance that you might not even be aware of, where previous legal advisors or previous financial advisors, accountants have given you poor advice or not done their job properly. A couple of examples I can think of. With transaction last year, there was tax issues which were raised, P11D benefits, where fleet of company vehicles had never had, alleged company vehicles had never had P11D tax benefits on them, even though some of the vehicles were Harley-Davidson motorcycles and whatever. And clearly HMRC are not going to say that is a company vehicle. So that led to the buy side calculating potential tax liability over 10 years of 1.8 million. So these could be dealt with in advance of the live arena. Two final examples of chipping, in actual fact, one which led to the transaction falling apart. We were in a live arena. Client did not want to engage to do pre-due diligence. We're happy to do it in a live setting. And it was discovered early in the process, in the live process, that there was an EMI share option scheme in place, which had been in place for 10 years. But the law firm who had acted on that, I hasten to add, not Pepperells, had not registered this with HMRC and had not got clearance. So it was a null and void scheme. So there were 150 staff who thought they had share options who didn't, and the buyer walked away immediately. So it really is super, super important. And one final example I can give, not stealing my colleague Mark's property thunder, but we did a transaction last year, sale of a electronics business, and they had a 50,000 square foot property and premises with land, and they'd built a 5,000 square foot storage facility in the perimeter of the land. But when we did the property due diligence, we found that the solicitor who'd done the conveyancing, again not Pepperells, had not conveyed the whole of the land, and they'd actually built this new building on land they didn't even own. So this is why, these are things that a business owner would not necessarily know of, or probably would not know of. They just assume the solicitors that they've engaged have done their job properly. The accountants are giving them proper tax advice, and that isn't always the case. So I hope that's underlined why it is important to do pre-due diligence and not just in a live setting. Rachel, if I have the next one. So the due diligence questionnaire. It is long. It will cover a whole load of aspects. And in that slide, you can just see, this is what we would call a typical, in inverted commas, due diligence questionnaire that you as business owners and we as advisors would expect to see from the buy side. If anyone would like a full due diligence questionnaire that they can use as an memoir, or perhaps use as a document to start working, pulling things together to make sure you are compliant with all of these things. They're little insurance policies in themselves, actually. So even if you're not yet preparing your business for sale, these are things that you should always have in place anyway to mitigate risk. So start off with your corporate structure record. So share certificates, your statutory books, copies of all board minutes, shareholder minutes, resolutions, AGMs, that sort of thing. Then we look into the main aspects of finance, banking, and accounts. Usually, typically go back 3 years, often 5 years. Key part is the contracts and the trading. I've already said in my last slide the importance of your contracts with your suppliers. This is something that is gone into in great detail by the buyer side. If you have a contract with a supplier, say it's worth 100,000 a year, the buyer will want to know that they can get out of that contract if they wish. So if you've signed it with a supplier of IT for 100 grand a year and it's a 10-year contract without any break provision in, then that's likely to put off a buyer and they'll chip the price because they want to have control of bringing in either in-house or with their own third-party suppliers, contracts for services, contracts for hire and the like. So it's really important to look over these contracts and don't just sign them willy-nilly. If you wish to have someone in our team look over them, we normally just do that. It's a very short 1 hour thing. It's so important before just signing. They look at intellectual property. Do you own it? Have you got registered trademarks? Are there any patents? That sort of thing. And then when we're looking into further down, I'm skipping through this. I know we're not a huge amount of time. Any litigation? So have you got any actual pending or intimated claims, whether from employees, former employees, customers, clients, Environment Agency, Health and Safety Executive, HMRC? So that will be delved into quite extensively. Employment terms, contracts of employment, they'll want to know that you have relevant notice provisions in there, restricted covenants to stop key employees going off and setting up in competition. Then we look at pension schemes. Your property is held in freehold, leasehold, and Mark will come on and discuss that in a little more detail. What's your health and safety records like? Have you ever had any claims? And the big one, tax. They'll look very, very carefully at tax in all of its aspects. Have you paid the amount that is appropriate? Are there any issues that could give rise to HMRC coming in to unravel anything? So these are all extremely important. And although that's only 16 subheadings there, within there, there's possibly 70, 80 pages, 150, 160 different questions and sections within that broad context, which is again why I urge any business owner who is looking to exit to do so in a timely manner and really, really prepare to do this in advance of the live transaction. Slide, please, Rachel. I may now hand over to give my voice of rest to my colleague, Mark Stevenson, who's a commercial property lawyer in our team.
Thanks, Peter. So just to follow on and touch on the due diligence side of your property, I think the first question is, does a buyer want what you've got? And this will ultimately depend on what it is you're doing. if you're, say, you're selling an accountancy firm, then they may well need the premises to house all your accountants that they're taking over, etc. Alternatively, if you're looking at, say, warehousing for storage of items, then potentially they may not need it if they have their own warehouse. So again, it's something to find out early on, because if you're going to sell a business and the buyer doesn't want the property that you've got, then what you're going to do, you're going to need to get rid of it. And then that takes us to, if it's lease, how are you going to get rid of it? I'll touch on that in a second. And importantly, how many properties do you have? It may sound a silly question, but Peter gave an example the other day of a seller not disclosing the number of properties they had until well down the line, which it's going to delay matters, as any buyer, if they are taking the property, is going to have to enter into extensive due diligence on each of the properties. So not disclosing the exact numbers, again, just going to cause delays further on. And who owns the property? Another important question: is this in your personal name? Is it your business? Is it in a company name? Is the property within the business? Is it in a pension fund? There's a lot of variations to how the property can be held, and then that is going to affect how the property is conveyed on the basis that they do want to take the property. And thinking particularly in relation to pension funds, where often we have professional trustees who are registered proprietors, as well as the actual pension holder themselves, that if we need to get them involved and get their consent and permission, that can all take a fair bit of time, and there's a lot of hoops to jump through as well once you start getting involved with the pension company. And it's best to do that in an early stage, so we can identify A, who are the pension trustees, and B, that they do agree to the sale or the perhaps assignment, etc. And the extent of the property, and as Peter just touched on earlier in this seminar, do you actually own all the land on which your buildings sit? And again, sounds stupid, but as I say, the example that Peter gave, it's not always the case, and I suppose it's about identifying the area early on and just making sure that you do, in fact, you have built on the correct land. And again, that comes back to your legal advice at the time. So moving on to, once we've satisfied those basic points, then looking at the property as a whole and splitting it really at this point between leasehold and freehold. Dealing with the leasehold side of things first, and alienation, which is not the 1988 film. It's assigning and underletting your lease. And in order to do this, you're going to need consent of the landlord. So again, there's various provisions in the lease usually that need to be satisfied before consent will be granted, and it's better to start that process earlier on and ensure the landlord is on board, because if you haven't complied with the conditions to, say, assign your lease, then the landlord can refuse. And the buyer, if they can't get the property, if the property is integral to the business and the landlord's refusing an assignment, then that could be a big sticking point. I mean, there may well be ways around it, but at the end of the day, if we can deal with those up front and have it conveyed as part of the business sale, then so much the better. Consent to dealing. Again, this coming back to the landlord here. And again, not just their actual consent, but they can also impose conditions on the actual assignment. So things like, they'll probably require, if they do agree to you signing the lease, they'll probably want you to give a authorized guarantee agreement, but they may also be able to request that the buyer provides further guarantors or perhaps rent deposits and things like this. And again, whether it's reasonable, that you potentially can argue the point, but ultimately, it's knowing what the landlord requires, really. That's what we need to know in order to be able to say to your buyers, well, we know we're going to be in a position to actually convey the property to you. This then brings up the acceptable terms. And what I'm getting at here is whether the buyer is happy with the terms of your lease. And this, I would say the biggest sticking point I see is where potentially clients haven't had a lawyer instructed when they first took the lease. And as a result of that, they've simply accepted all the landlord's conditions and clauses, which is fine to a degree, but it ultimately does tend to be quite onerous on the tenant, and perhaps a more commercially minded buyer may not appreciate all the clauses that you have in your lease as a result of that. So it's identifying those early, I suppose. And I mean, the thing is with that, there's only so much you can do, because you will have entered into the lease at that point. But again, if there are going to be clauses in there that are deal breakers to your buyer, then there doesn't seem much point in going all the way down the line to find this out. It's better to find it out early on, because if it's going to scupper the deal, then the sooner you know about it, the better. That said, I wouldn't really expect there to be anything in there that would actually dissuade a buyer from proceeding, but it's very subjective. So you don't really know until you're in that position. Break clauses, very useful for tenants. If you don't have, if the buyer doesn't want your property and you're going to be stuck with a lease that has maybe 5 years left to run, if you've got a break clause, well, that may at least mitigate some of the remaining term. So if you've got a break clause after, say, 3 years and you're 2 years into it and selling, then okay, you may end up paying a year's worth of rent, but it's better than paying 3 years of rent if you've got a 5-year lease overall. So beneficial there. The other point I mentioned about break clauses, quite often landlords trying to make them personal to the original tenant. So if it is a personal break clause, that won't be capable of assignment to your buyer. And at that point, it may be that a discussion needs to be had with the buyer. Do they want the property? If so, you can assign it, and then they'll take it without the break clause. Or alternatively, do they want a new lease, perhaps from the landlord? In which case, you can maybe exercise the break, and the landlord will agree to enter into a new lease with the buyer. So, if you are going to go down that route, there are break clauses very strictly interpreted, and there would be various notices and various conditions that need to be satisfied, and that is, as I say, it's very strict, so it needs to be looked at quite early on to make sure that the break clause can indeed be exercised validly. And condition of the property, this is a big one, because it could be quite expensive for any potential buyer. And ultimately, it comes down to how good a care of the property you've taken. And it is the rough dilapidations claim is in the region of equal to the last year of rent. So they can be quite significant. And if your buyer is looking at the property thinking, well, there's a lot of work to do here, then that could make them it could either, again, potentially scupper the transaction, or alternatively, they could turn around and say, well, actually, we're not going to take this property at all. So, you may be a case of having to do perhaps a condition survey, and then undertaking some of the works that are identified, so that at least you can put right some of the repairing works. In which case, your buyer might look at it, and if their subsequent liabilities being diminished by the works you've done, then that might be fine, and they might be prepared to take more of a risk on that. Because, regardless, with any lease, regardless of the condition, there'll always be some works required at the end of it. And alterations, have they been carried out with consent, for example? And have they been built in accordance with building regs and things like this? Guarantees, collateral warranties, are all these documents available? And it probably depends on the scale of the alteration or the addition to the building as to, well, for a start, whether there are collateral warranties. But then looking further into that with such things as collateral warranties, are they going to be novated? Can we assign them? I mean, with warranties, it's usually a case of novation, which means trying to get hold of the original parties to the warranties. So how long ago was it that the warranties were first granted? So that can take quite a lot of time to actually get arranged when you're looking at novation. So moving on to freeholds, searches. I mean, chances are your buyer will certainly undertake some searches on the property, and the big one these days is contamination. A lot of potential past users can put the property at risk. Is this going to deter a buyer? And I mean, that's a very subjective question, and it really does depend on what the risk was or is, and what the property is used for, and perhaps future intention for the property. But again, it's knowing in advance whether it's potentially going to be an issue. And the permitted user, are there any prohibitions in the title against the property being used for a particular use? The most common restrictions we see on title for use relate to not using for the sale or manufacture of alcohol. Now, you're not really going to see those sort of restrictions in industrial areas, well, industrial parks. So probably not too much of an issue there. You might find the odd restrictive covenant there. You again, with restrictive covenants, first off, are they still any benefit? And there are ways to remove them if there's no benefit remaining. And again, it's identifying whether there's that benefit. And the application can be made to Land Registry if there's perceived to be no benefit to anybody anymore, which is, that's great, get rid of it. But again, if you identify that early on, make that application, take it off the title. If you can give a buyer a clean title, then it'll make the transaction go much smoother. I mean, some restrictive covenants can be, if you have to pay to remove them, it can be very costly. Excuse me.
Matt, just conscious of time, it's going to be an hour long. I just wondered if you could just quickly go through the remaining points.
Okay.
Because I know there's Ella yet to do her bit as well.
Fine. Okay. So subject to leases. If you're selling within the property, perhaps I'd say you've got a large property and it's been maybe subdivided and you've underlet or assigned parts, then there may be some underlying leases there that you're also selling to third parties. And again, it's ensuring that they are in place and everything is valid, tenants identified, etc. Service charges, have they been audited? A buyer, if you're imposing a service charge, the buyer will want to see audited accounts, etc. Basis for the imposition of the charge in the first place. And that can take a while to compile all that sort of information. If you're selling part of the property only, say you're retaining part for yourself, for example, then we're into trying to define what rights are actually needed for you and the buyer going forward, and then coming to an agreement as well on how, say, access rights, for instance, how that's going to work, who's going to maintain roads, etc. Excuse me. So moving on to more general matters that apply to sort of leasehold and freehold together. Is there a mortgage on the property? What's going to happen with that? How's the business being sold? Is it a share sale, asset sale? If we're looking at a more asset sale, then are we repaying the mortgage? If we are, that's fine. But then there's potential consent to leases and things like that if we're looking at any leasehold property. And access to property, as I touched on before, if you've sold part, that comes back to arranging who would maintain any land that would be used jointly between you and the buyer. What about licenses? Any licenses required to run the business? Most common and easiest example is, say, a premises license. So is that to be assigned? Excuse me. And lastly, capital allowance. On a sale of property, the capital allowances can be passed on. They can be quite significant, and as a rough guide, the estimate for capital allowance relief gain to a seller is around 10% of the sale value. But this has got to be, it's claimed as a relief, as a tax relief. Now, not a lot of people actually deal with this, and it can quite often just be sold or simply ignored. Excuse me. And the danger of ignoring it is that if you have made a capital allowance claim and you haven't told the buyer and you haven't entered into an election with your buyer, and the buyer subsequently makes a claim, you could well be liable for all the previous tax relief you've received. So it's important to address that point early on and get as much information up front as possible. And the only other thing I'll say on that is the alternative is that you may well be able to keep the capital allowance tax relief inherent in the property even post-sale for a couple of years. So again, it's worth knowing about that, and that can be agreed with the buyer at the outset. So with that, I shall pass on to my colleagues.
Thanks, Mark. So I'm just going to touch upon the importance of agreeing heads of terms. So what are heads of terms? So heads of terms, also known as sometimes as letters.
Ella, I'm struggling to hear you. Can you just come a bit close to the mic? It's just cutting out.
What are heads of terms? Is that any better? Yeah, perfect. What are heads of terms? So heads of terms are often known as letters of intent, memorandum of understanding, heads of agreement, for example. Essentially, these are document which sets the terms of the transactions agreed between the parties. Heads of terms evidence serious intent, but are not. They don't. Serious intent, but do not legally compel the parties to complete on those terms. However, provisions relating to confidentiality and costs may be binding upon the parties. So heads of terms are used for a number of purposes. So for example, they can be used as written confirmation of the main terms of the agreements in principle. They can also be used to outline timetable and obligations on the parties. So they're commonly entered into at the beginning of the transaction and before due diligence and before kind of the main documents are entered into. So I'm just going to kind of run through what heads of terms generally include. So they include a number of things. They will always deal with consideration. So how this is paid, for example, is it paid in deferred payments? Is it paid in earn-outs, or is it just a lump sum on completion? They will sometimes deal with assumptions. So how much cash should be in the bank on completion, whether the debtors should be cleared, that kind of thing. If there's deferred payments, we usually touch upon whether these should be secure, whether there should be any security in place for these. They will usually also deal with exclusivity and confidentiality provisions. And they will also sometimes can deal with specific provisions that need to be in the SPA. So for example, whether the seller will enter into any restrictive covenants, for example. And then they will also touch upon the target completion date. So get your lawyers involved from the start, and definitely when you're agreeing ahead of terms. And this is always a piece of advice that we'll give to clients. And this is because we need to be there to make sure everything is included in the heads of terms. Because often you find that security isn't mentioned at all in the heads of terms. And then the seller will want some sort of security negotiated later when we're kind of agreeing the SPA. And this, from experience, buyers aren't generally wanting to put this in if it's not in. Thanks, Rachel.
So I don't know if everybody could hear that very clearly, but Ella, I think it might be helpful for you to just send a summary so we can circulate to all our attendees just a little bit about heads of terms. But just if anybody didn't hear that clearly, the heads of terms is the first document that will go into that sale process with that one particular buyer, and that is really to set the scene of what the deal is. It's not where we would agree the full contract, but it's setting the scene. But Ella, if you can do as a summary, and we'll circulate that to all our attendees, that'll be really helpful.
Sorry, everyone.